Salam sejahtera to Madam Ida, our lecturer of PD 30803. We are from Group 10. My name is Michelle Chung, and today I want to present the issue 1 in question 1. So the issue is whether Bank Papaya is liable for negligently paying out the fork check. In order to support this issue, we need to look at the rules. So the rules that we use is from the Bills of Exchange Act 1949 in Section 24 and Section 73A. In Section 24 stated that any fork check cannot be paid out as it is without the consent of the person who has the rightful authorized. This is similar to the case of United Asian Bank versus Tai Sun Heng Construction Sdn Bhd 1993, where the court rules the bank was liable to pay out fork check without real authority from the rightful. Next is Section 73A, where signature is purported to be knowingly or negligently contribute to the forgery. This law can be interpreted that the bank in good faith is not liable to the fork check if the customer is negligently contribute in making of the forgery. This is similar to the two cases here. Both of these cases are governed under the rules of Macmillan duty and Greenwood duty. In this case, Bank Papaya is defendant and Toya is plaintiff. So for the application, in this case, Toya has opened a current account with Bank Papaya and prohibited her employees from signing on behalf of the salon. Nana, one of the employees without the consent and authority, has forged a signature and filled in 10,000 ringgit and cashed it at the Bank Papaya. Bank Papaya clerk, Mr. Matkul, has suspicious with the check, but he paid it anyway. Based on Section 24, the bank is wrongfully to pay out the fork check as it is without the consent of the person who has the rightful authorized. This is similar to the case of United Asian Bank BHD versus Tai Sun Heng Construction SDN BHD. The plaintiff already set a rule to restrict the employee from signing the check. Therefore, the plaintiff has proven to conduct her Macmillan duty implies she is not being negligent in preventing fork check. It is true that based on Section 73A, the bank is protected if the customer is proven negligent, but the defendant on the other side has suspicious to the check but didn't take any effort to justify thoroughly the fork check, showing the bank is negligent is preventing forgery. This is aligning with the case of CIMB versus Penneron Control Sdn Bhd. In this case, the bank is liable due to failure in maintaining proper verification and authentication protocol. So, as a conclusion, Bank Papaya is liable for negligence in paying out a fork check. This is mainly due to the fact that Bank Papaya pays a check where the signature has been forged, which would be liable for payment without any mandate or authority to debit the customer account.
Hello, my name is Abdullah bin Nasran. So the next issue is whether Bank Jaya is liable for paying out the check to the wrong person. Now move on to the rule. The banker duty is to pay on the right person accordingly to the customer mandate, which known as the drawer. If the banker deposit to the wrong person, then he is liable to bear the loss. The customer can get protection from the rule of law in Malaysia. In the law of Malaysia under the Section 79 Bill of Exchange Act 1949 involving the cross-check, especially when the cross-check are crossed by more than one banker, he is liable to refuse the payment in the situation. Other than that, when the banker or agent receive any cross-check from a person as a payment, then the total amount of payment will stay the same and the banker are liable to any loss for the original owner of the check because all check will be marked as paid, except when the check has been shown as payment whether it is not been crossed yet or the cross has been removed and modified other than as authorized by this law. The banker which made the payment for the check with a good faith and without any negligence will not be necessarily be liable to the situation. At the same time, the payment will not be questioned by the reason of the check whether has been crossed or been modified and removed to any situation other than as authorized by the law. Additionally, also will not question question if the banker or any agent already made the payment of the check or any cases related to this law. It gives the paying banker some protection against the loss of the right to debit his customer account when he deposited a check to the wrong person. Now move on to the application. Zen Jati Sendirian Berhad had received cross check not negotiable with total amount of 15,000 ringgit from Toya. The issue started when the power of Zen Jati, which is Zen, went to Bank Papaya in purpose of deposit of the check into the Zen Jati Sendirian Berhad account. Since Zen's brother also has a different company named to Zeno Jati Sendirian Berhad, Bank Papaya deposited the check into the wrong account and Zen Jati Sendirian Berhad did not receive any deposited check from Bank Papaya without Zen knowing about it. When Zen started to realize the fact happened on this issue, he rushed to the Bank Papaya to inform about the situation, but at the same time, the Bank Papaya are delayed to take action for countermand the payment that has been made by Zen until all the money has been taken away by Zeno. As we can see from the issue that Bank Jaya are not able to protect their right due to the negligence occur when the Bank Jaya delaying the countermand, which shows that they are not showing good faith toward their customer. The law has already stated that where the bank should not negligence if they want to protect their right. In this case, Zen can take legal action toward Bank Jaya to recover his loss from the wrongly deposited money into Zeno Sendirian Berhad account due to the negligence by the bank. Additionally, the check is special crossing because it is written not negotiable, which only applicable to be used on specific people as the name are displayed on the check depending on the owner's choice. It is clearly stated under the section 17(6) Bill of Exchange Act, the paying banker duty is to pay to the right person according to his customer drawer's mandate. If the banker pays to the wrong person, he must bear the loss. So in conclusion, Bank Jaya is likely liable for paying out the check to the wrong person. It is because of their negligence on delaying the countermand process which has led to Zen loss. The bank can only protect their right if they had avoiding the negligence and showing a good faith toward their customer. Customers are the main asset of the bank which help them to expand widely. All banks should be considered their customer by giving a good services in any situation. So that is all from me. Thank you.
Hello, my name is Evan Charles Werfen, and now we are moving to the next discussion. The case I'm referring to is question B, which is about Luigi, who found out about the unauthorized withdrawal amounted 3,000 ringgit. He then proceeded to justify the withdrawal at the Bank Papaya, but the bank denied the responsibility. So to start the discussion, we need to determine the issue first. The issue is whether the bank is negligent in facilitating the unauthorized withdrawal, thereby liable to the losses. We then need to identify the factors that may support this issue. Next part is the rule. The first rule is regarding the ATM verification and authorization. As you can see on the slide, ATM depend on customer verification and authorization system using credit card, either 4 or 6 PIN code. Along with that, customer must also use a specific plastic card bank with chips or metal strip to access the ATM. Next is the phantom withdrawal. Phantom withdrawal is removal of funds from the owner account without consent or knowledge about it. It indicates that this is usually done by third party, and BNM has stated that most of the factors lead to this phenomena is due to leaked private information or financial information by the account owner, either they realize it or not. Under this situation, either bank or customer, both is not liable, but generally, most of the time, the customer takes the losses. However, this fact by BNM doesn't provide any protection to the bank being liable due to inside job or on negligence. Maintaining security is their responsibility. So for the application, according to case, again, Luigi found out about the unauthorized withdrawal and go to the bank to settle the matter. However, the bank said that it is a valid withdrawal due to successful transaction. According to the rule, you need unique PIN code, 4 to 6 digit, and specific card to access your bank account. Nobody should have access to your account as only you have all the requirement. Bank Papaya merely suggesting the possibility of Luigi negligence and no solid evidence to show to him. Luigi then accused the bank for fraud and negligence. The bank didn't provide any evidence to protect themselves. As conclusion, the bank Papaya is likely liable. This is because there is no solid evidence and the bank just merely suggesting that it is Luigi's fault. No record history or CCTV shows to him to prove that the withdrawal is valid and failed to respond to the accuse of possible hacking and unauthorized access by other party.
Okay, my name is Awang Muhammad Abdul Hanafi bin Pangeran Muhammad Yusri and I would like to continue with the presentation. Okay. What are the issues? The issue are whether Luigi is able to take a legal action toward the bank for the unprofessionalism in managing problem to exercise his right as a customer of the bank. The rules and application. First, for the rule. In the United States, under the section of 4.104(1), according to the Uniform Commercial Code, it has been stated that when a person tries to open up an account in the bank, they are being called as customer of the bank. The perk of being a customer of the bank are they were being taken care of by the banker, as it is their duty to honor such check, withdraw money without the authority or consent of the account holder, duty of confidential privacy, and to take care of the account of the customers, which this will indicate that the customer can carry out his customer's right against the banks when he is able to prove that he is a client. More or less, it was a bank duty to inform and provide the customer with the information without making any necessary action to the account holder. Customers' right are the right to fair treatment by the bank and the right to grievance redressal and compensation. Customers should be treated without being judged based on their appearance, age, occupation, and gender. If anything that happened that is not desirable with the bank, the customer is able to seek for the financial ombudsman since it was under the FSA and the IFSA in the section of 126. Other than that, customers are also able to discuss this for the Tribunal Consumer Claim based on the Consumer Protection Act 1999. Okay. Next will be the application. When Luigi informed to the bank regarding the balance in his account were missing or short of 3000 RM, he has fulfilled his duty as a customer of the bank, where he informed the bank due to the suspicious activity on his account. Upon receiving his statement of balance, he did not know what happened to his account, as the bank failed to inform and provide him any information that has related to his account. For example, whether it's a commission charge, student loan, probably a set-off. Before issuing or paying anything from the customer account, it was the bank duty to get the authority, confirmation, and notice of the customer. In addition, when Luigi decided to meet and complain it to the Bank Papaya manager, which is Mr. Rupa make a false assumption and accusation that it was the customer's fault, where he probably forgot about it and there is nothing they can do, and they don't need to do anything about the money, where they don't need to do anything about the money as nothing happened, which Mr. Rupa quote, "There's nothing can be done. Luigi have the right to be treated fairly as a customer of the bank." When Mr. Rupa unable to do something for Luigi, but according to the Establishment Ombudsman Scheme, OBOFOS, once Luigi seek for the financial ombudsman, he is unable to appeal the claim but able to bring this matter to court if the situation is also undesirable for the customers, which this lead to the conclusion. To answer this issue, yes, he can. As a customer of the bank, Luigi are able to take legal action toward the bank for the unprofessionalism in managing their problem. Due to, first, the bank has mistreated Luigi in an inconvenient dire situation. Secondly, there have been no action by the bank to recover and to track what happened to the customer's money in his account. For example, finding out through security check in the system, as it could really help the customers. And lastly, it is also because the bank is not informing the customer really well as not doing their duty rightly. This is probably because of lack of training in the management, that the banker does not know what to do regarding their duties as well as their job. That is all.